Okay, so now we're going to do our second evidence video, and this is going to be Federal Rules of Evidence, Article 1, General Provisions. So let's see how much we can get done here. So, Rule 101, the scope and the definition. So, scope. These rules apply to proceedings in United States court. The specific courts and proceedings to which the rules apply, along with exceptions, are set out in Rule 1101. Definitions in these rules. Number one, civil case means a civil action or proceeding. Number two, criminal case includes a criminal proceeding. Number three, public office includes a public agency. Number four, record includes a memorandum, report, or data compilation. Number five, a rule prescribed by the Supreme Court means a rule adopted by the Supreme Court under statutory authority. And number six, a reference to any kind of written material or any other medium includes electronically stored information. So we see all the changes that have gone towards the general provisions. Okay, so let us move on to Rule 102, the purpose. What is the purpose of this? These rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing a just determination. So these rules are how do we administer a proceeding fairly. We don't want to spend too much money. We don't want to delay it. We really want to promote the development of evidence law, and we want to find out the truth and make a fair determination. So that is the purpose of the rules, the federal rules of evidence. So now rulings on evidence, Rule 103, preserving a claim of error. A party may claim error in a ruling to admit or exclude evidence only if the error affects a substantial right of the party. And number one, if the ruling admits evidence, a party on the record A, timely objects or moves to strike, and B, states the specific ground unless it was apparent from the context, or two, if the ruling excludes evidence, a party informs the court of its substance by an offer of proof unless the substance was apparent from the context. B, not needing to renew an objection or offer of proof. Once the court rules definitively on the record, either before or at trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. Court statement about the ruling directing an offer of proof. The court may make any statement about the character or form of the evidence, the objection made, and the ruling. The court may direct that an offer of proof be made in question and answer form. D, preventing the jury from hearing inadmissible evidence to the extent practicable, to the extent practical or practical. The court may conduct a jury trial so that inadmissible evidence is not suggested to the jury by any means. And E, taking notice of plain error. A court may take notice of plain error affecting a substantial right, even if the claim of error was not properly preserved. All right, so here are the changes. Let's just look at this here. The wording of the plain error principle is from Rule 52B of the Federal Rules of Criminal Procedure. While judicial unwillingness may be constructed by mechanical breakdowns of the adversary system has been more pronounced in criminal cases, there is no scarcity of decisions to the same effect in civil cases. In general, see Campbell, extent to which courts of review will consider questions not properly raised and preserved. All right. In the nature of things, the application of the plain error rule will be more likely with respect to the admission of evidence than to exclusion, since failure to comply with normal requirements of offers of proof is likely to produce a record which simply does not disclose the error. All right, so there we have, oh, does this go to the next one? Yeah. Rule 104, preliminary questions. Rule 104, preliminary questions. A, in general, the court must decide any preliminary question about whether a witness is qualified, a privilege exists, or evidence is admissible. In so doing, the court is not bound by evidence rules except those on privilege. Relevance, that depends on a fact. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. C, conducting a hearing so that the jury cannot hear it. The court must conduct any hearing on a preliminary question so that the jury cannot hear it if, number one, the hearing involves the admissibility of a confession. Number two, a defendant in a criminal case is a witness and so requests. Or number three, justice so requires. D, cross-examining a defendant in a criminal case by testifying on a preliminary question. A defendant in a criminal case does not become subject to cross-examination on other issues in the case. E, evidence relevant to weight and credibility. This rule does not limit a party's right to introduce before the jury evidence that is relevant to the weight or credibility of other evidence. All right, let's go here to Rule 105, limiting evidence. Rule 105, limiting evidence that is not admissible against other parties or for other purposes. If the court admits evidence that is admissible against a party or for a purpose, but not against another party or for another purpose, the court on timely request must restrict the evidence to its proper scope and instruct the jury accordingly. So a close relationship exists between this rule and Rule 403, which we'll get to later, which requires exclusion when probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading of the jury. So here we have it. So limiting evidence that is not admissible against other parties or for other purposes. So the court can admit evidence that is admissible against a party or for a purpose, but not against another party or for another purpose. The court, on timely request, must restrict the evidence to its proper scope and instruct the jury accordingly. So you have to instruct the jury so that they view the evidence in the proper scope. It is for this party and this purpose. This evidence is not to be used against another party or for another purpose. All right, let's move on to Rule 106. Reminder of or related writings or recorded statements. If a party introduces all or part of a writing or recorded statement, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time. So the rule is an expression of the rule of completeness. McCormick, Section 56. It is manifested as to dispositions in Rule 32A4 of the Federal Rule of Civil Procedures, of which the proposed rule is substantially a restatement. The rule is based on two considerations. The first is the misleading impression created by taking matters out of context. The second is the inadequacy of repair work when delayed to a point later in the trial. So the rule does not in any way circumscribe the right of the adversary to develop the matter on cross-examination or as part of his own case. For practical reasons, the rule is limited to writings and recorded statements and does not apply to conversations. So if a party introduces all or part of a writing or recorded statement, the adverse party may require the introduction at the same time of any other part or any other writings or recorded statement that in fairness ought to be considered at the same time. So this, I believe, if I understand this correctly, would how you could cherry pick from a document. And so you need to be able to see the document in its whole or anything else that would, allow you to, in fairness, consider it at the same time. So that's what this is telling us here. And I think that takes us to Article 2, which will be our next video. Thank you so much for tuning in to listen to Article 1 of the Federal Rules of Evidence. See you in the next video. Thank you so much, Bar Exam Drills, for your support, and the Marchica Law Firm for your support in my journey to self-study for a career in law. Thank you so much.